But in order to apply this to the particular exigencies of each individual, it is still necessary to have recourse to reason, whose office it is to discover, as was before observed, what the law of nature directs in every circumstance of life, by considering what method will tend to most effectually to our own substantial happiness. And if our reason were always, as in our first ancestor before his transgression, clear and perfect, unruffled by passions, unclouded by prejudice, unimpaired by disease or intemperance, the task would be pleasant and easy. We should need no other guide but this. But every man now finds the contrary in his own experience, that his reason is corrupt, and his understanding full of ignorance and error. This has given manifold occasion for the benign interposition of divine providence, which, in companion to the frailty, the imperfection, and the blindness of human reason, hath been pleased, at sundry times and in divers manners, to discover and enforce its laws by an immediate and direct revelation. The doctrines thus delivered we call the revealed or divine law, and they are to be found only in the Holy Scriptures. These precepts, when revealed, are found upon comparison to be really a part of the original law of nature, as they tend in all their consequences to man's felicity. But we are not from thence to conclude that the knowledge of these truths was attainable by reason, in its present corrupted state, since we find that, until they were revealed, they were hid from the wisdom of ages. As then, the moral precepts of this law are indeed the same original with those of the law of nature, so their intrinsic obligation is of equal strength and perpetuity. Yet undoubtedly the revealed law is, humanly speaking, of infinitely more authority than what we generally call the natural law, because one is the law of nature, expressly declared so to be by God himself. The other is only what, by the assistance of human reason, we imagine to be that law. If we could be as certain of the latter as we are of the former, both would have an equal authority. But till then, they can never be put in any competition together. Upon these two foundations, the law of nature and the law of revelation, depend all human laws. That is to say, no human laws should be suffered to contradict these. There is, it is true, a great number of indifferent points, in which both the divine and the natural leave a man at his own liberty, but which are found necessary for the benefit of society to be restrained within certain limits. And herein it is that human laws have their greatest force and efficacy. For, with regard to such points as are not indifferent, human laws are only declaratory of, and act in subordination to, the former. To instance, in the case of murder, this is expressly forbidden by the divine, and demonstrably by the natural law, and from these prohibitions arises the true unlawfulness of this crime. Those human laws that annex a punishment to it do not at all increase its moral guilt, or superadd any fresh obligation in foro conscientiae to abstain from its perpetration. Nay, if any human law should allow or enjoin us to commit it, we are bound to transgress that human law, or else we must offend both the natural and the divine. But with regard to matters that are in themselves indifferent, and are not commended or forbidden by those superior laws, such for instance as exporting of wool into foreign countries, here the inferior legislature has scope and opportunity to interpose, and to make that action unlawful, which before was not so. If man were to live in a state of nature, unconnected with other individuals, there would be no occasion for any other laws than the law of nature and the law of God. Neither could any other law possibly exist, for a law always supposes some superior who is to make it, and in a state of nature we are all equal, without any other superior but him who is the author of our being. But man was formed for society, and, as is demonstrated by the writers on this subject, is neither capable of living alone, nor indeed has the courage to do it. However, as it is impossible for the whole race of mankind to be united in one great society, they must necessarily divide into many, and form separate states, commonwealths, and nations, entirely independent of each other, and yet liable to a mutual intercourse. Hence arises a third kind of law to regulate this mutual intercourse, called the law of nations, which, as none of these states will acknowledge a superiority in the other, cannot be dictated by either, but depends entirely upon the rules of natural law, or upon mutual compacts, treaties, leagues, and agreements between these several communities, in the construction also of which compacts we have no other rule to resort to but the law of nature, being the only one to which both communities are equally subject. And therefore the civil law very justly observed that quod naturalis ratio inter omnes homines constituit, vocatur ius gentium. Thus much I thought it necessary to premise concerning the law of nature, the revealed law, and the law of nations, before I proceed to treat more fully of the principal subject of this section, municipal or civil law, that is, the rule by which particular districts, communities, or nations are governed, being thus defined by Justinian, Ius civile est quod quisque sivi populus constituit. I call it municipal law, in compliance with common speech, for, though strictly that expression denotes the particular customs of one single municipium, or free town, yet it may be sufficient propriety to be applied in any one state or nation which is governed by the same laws and customs. Municipal law, thus understood, is properly defined to be a rule of civil conduct prescribed by the supreme power in a state, commanding what is right, and prohibiting what is wrong. Let us endeavor to explain its several properties, as they arise out of this definition. And first, it is a rule, not a transient sudden order from a superior to, or concerning a particular person, but something permanent, uniform, and universal. Therefore, a particular act of the legislature to confiscate the goods of Titius, or to attain him of high treason, does not enter into the idea of a municipal law, for the operation of this act is spent upon Titius only, and has no relation to the community in general. It is rather a sentence than a law, but an act to declare that the crime of which Titius is accused shall be deemed high treason. This has permanency, uniformity, and universality, and therefore is properly a rule. It is also called a rule, to distinguish it from advice or counsel, which we are at liberty to follow or not, as we see proper, and to judge upon the reasonableness or unreasonableness of the thing advised. Whereas our obedience to the law depends not only upon our approbation, but upon the Maker's will